Welcome to The Explainer. Today, we're going to tackle a topic that sounds complicated, but is so important: probate. Think of it as the official playbook for what happens to someone's stuff after they're gone. And, getting a handle on it is absolutely key to making sure a legacy is protected.
All right, so here's the game plan. We'll kick things off with what probate actually is. Then we'll look at the two big scenarios: what happens when there is a will and what happens when there isn't. We'll also dive into the drama: what happens when people disagree. And finally, we'll wrap it all up with the stuff you really need to remember.
It's a huge question, one we all think about at some point. After a person is gone, what happens to everything they've built? Who gets to step in and handle their bank accounts, their home, all their belongings? Well, there's a legal answer for that, and it's a specific process designed to make sure everything is handed over in a fair and orderly way.
So, what is probate really? At its heart, it's the legal system's official handover process. It's the court making sure that a will is legit, all the bills and debts get paid, and then whatever's left over gets passed on to the right people. It's the rule book for closing out someone's financial life.
And let me tell you, the law does not mess around with this. There's this old legal principle hammered home in cases like Bank of West Africa versus Ricketts that basically says if you jump the gun and start messing with someone's estate before the court gives you the go-ahead, you become what's called an executor de suntort. That's a fancy way of saying an executor in your own wrong. And trust me, it can land you in some serious hot water, making you personally responsible for stuff.
Okay, so right here is the biggest fork in the road in this entire process. It all comes down to one question: did the person leave a valid will? If the answer is yes, they died testate, and the will is the rule book. If the answer is no, they died intestate, and suddenly the government's laws become the rule book. This one difference changes everything.
All right, let's head down that first path. This is the with a will journey, where we get to follow the rule book the person wrote for themselves.
So the will names someone called an executor to be in charge. Now here's a tricky little detail. The executor's power technically comes from the will the moment the person dies. But they can't actually do anything with that power until the court gives them the official stamp of approval. That stamp is called the grant of probate. It's the court saying, yep, this will is real and you're the one in charge, go for it.
So, assuming nobody's fighting about it, that's what non-contentious means, the process is pretty straightforward. Step 1, you find the will and file it with the court's probate registry. Step 2, the executor formally applies to the High Court. Step 3, they have to prove the will was signed and witnessed correctly, and if all the boxes are ticked, Step 4, the court issues that grant of probate. Simple as that.
Now, to get that grant, you've got to bring a whole stack of paperwork to the court. I mean, it makes sense, right? You need the application letter and an official copy of the will. You need proof that the person has actually passed away. That's the death certificate. You need to prove who you are and who they were. You even need to formally swear you're willing to do the job. And of course, they want to see what's in the estate, so you'll need things like bank certificates and property deeds. It's a lot, but it's all about being thorough.
Okay, let's switch gears and head down that second path. This is the no-will journey, where the person didn't leave a rule book, so the law has to write one for them. See, with no will, there's no executor, so the court has to step in and appoint someone to manage the estate. That person is called an administrator, and the piece of paper that gives them the legal authority to do anything is called the letters of administration. This is super important. Unlike an executor, an administrator has zero power until the moment the court issues this document.
So, who gets picked to be the administrator? Well, the law doesn't leave it to chance. It has a very strict pecking order. Right at the top of the list is the surviving spouse. If there's no spouse, it goes to the kids. No kids, it moves on to the parents. Then siblings, grandparents, and so on, all the way down the family tree. And get this, if there's absolutely no family to be found, even creditors can apply, just so the debts can get paid.
Okay, now here's a curveball for you. What happens if there is a will, but the person named as the executor can't or won't do the job? Maybe they've already passed away themselves, or they're too young, or they just say, no thanks. Well, the court doesn't just throw the will out. Instead, it issues something called letters of administration with the will annexed. It's a mouthful, I know, but it basically means the court appoints an administrator, but that administrator is legally bound to follow the instructions in the will. It's a hybrid, the best of both worlds.
So far, everything's been pretty smooth sailing. But, life isn't always like that. What happens when someone shouts, "Objection"? This is where we take a detour into what's called contentious probate. In other words, this is where the fights happen.
So let's say you're looking at a will and you think, wait a minute, something's not right here. Maybe you think the signature looks fake or that someone was pressured into signing it. Well, you can't just stand on the sidelines. The law gives you a formal way to raise your hand and say, hold on. And that's exactly what kicks off a contentious case.
And that's what we call a contentious grant, or sometimes probate in solemn form. I love that name because it sounds so serious, and it is. This is where things go from being a stack of paperwork to a full-on court case. The will has to be proven in front of a judge with people testifying and everything. So how you actually start this fight? The first move is to file something called a caveat. It's a fancy Latin word that just means let him beware. Think of it as hitting a giant pause button. You're officially telling the court, hey, don't issue any grants for this estate until I've had my say. It's a temporary stop, but it's a powerful first step.
But the person who's trying to get the grant isn't just stuck. They can respond with their own legal move, called a citation or a warning. This is them turning to the objector and saying, all right, you hit pause. Now the clock is ticking. You have to formally show up and tell the court exactly why you're objecting, or your little stop sign gets taken down. It's basically a put up or shut up notice.
So you can really see how this escalates, right? It starts with the caveat, the pause. Then comes the citation, the challenge. If the objector answers the challenge and formally states their case, that's called entering an appearance. And from there, boom, it becomes a full-blown probate action. That's just another name for a lawsuit, and it means a judge is going to have to sort it all out. Okay, we have been through a lot. The easy paths, the rocky detours, so let's zoom out and lock in the most important things to remember from all this. This little chart really breaks it down perfectly. When there's a will, you get a grant of probate. The authority flows straight from the will itself. The person who passed away chose the executor, and the will is their map. But when there's no will, you get letters of administration. The authority comes only from the court. The law picks the administrator based on that pecking order we talked about, and the rule book is whatever the state law says. Totally different worlds. You know, at the end of the day, understanding all this legal stuff isn't just an academic exercise. It's about people. It's about protecting your family from fighting and confusion when they're already going through one of the hardest times in their lives. And that's why having a clear, well-thought-out will is so powerful. It's not just a document. It's the best possible map you can leave for the people you love. The whole process, from start to finish, just screams one thing. Planning matters. Clear instructions matter. So I'll leave you with this to think about. If you sat down right now to write the rulebook for your own life's work, what would be the #1 most important instruction you'd want everyone to follow?